The United States Supreme Court has not yet ruled as to whether or not states can ban semi-automatic rifles. The Second Amendment says a well-regulated militia necessary to the security of a free state, the right of the people to keep bear arms shall not be infringed. From 1791, when the Second Amendment was adopted, until 2008, not one federal, state, or local gun regulation was struck down by the Supreme Court. The Supreme Court always said the Second Amendment means what it says. It's a right to have guns for militia service. But in 2008, the Supreme Court said there's a right of people to have handguns in their home for the sake of security. But the Supreme Court there said the Second Amendment is not absolute. The government can keep people who are perceived as dangerous, like with felony convictions for having guns. The court said the government would have guns in sensitive places, like airports and schools. And the Supreme Court said the government can prohibit particularly dangerous weapons. Since then, the Supreme Court has made clear that the Second Amendment should be interpreted based on history and tradition. So the question then becomes, in light of this law, can the government prohibit people from having semi-automatic rifles? And the lower courts have so far said that such laws are constitutional. And indeed, the Supreme Court on Monday, June 2nd, 2025, denied review in these cases. And so there's no answer from the Supreme Court, but the lower courts have allowed state governments to do this.